Okay, hello everyone. Oh, I'm sorry, I'm getting some feedback here. I'm sorry. Here, just hold for a second, please. Okay, I think I fixed that. Hello everyone, this is Ann Badmus. Thank you for attending our All About Immigration Q&A webinar today. I hope you all can hear and see me. Just to be sure, if anyone would just type into the chat pane, I can hear you. That way I know that we're not having technical difficulties in that way. So if you can hear me, please type yes, or I can hear you in the chat pane. Great, I'm getting yeses here, so good. Glad we're not having that kind of technical difficulty. So again, I want to thank you all for attending our All About Immigration Q&A webinar. I'm Ann Massey Badmus. I'm an immigration attorney with Sheaf and Stone. Many of you have worked with me in the past, some of you have not. But again, I want to thank you for attending, and hopefully this will be a session that will be helpful to you as you deal with immigration matters. So just before we get started, I wanted to go through a few of our Q&A webinar rules. If you could, please keep your questions to 2 to 3 sentences in length and no more than 1 question per attendee. We have a limited time here today, so I want to hopefully be able to answer everyone's questions. But if not, I will take note of the question and may contact you directly if necessary. So please, bear with us if it takes a little bit longer than expected. Also, please only ask general questions and do not disclose your personal or identifying information that will reveal your identity. This is a public forum, so we want to be careful not to disclose any confidential information. This is also the Q&A webinar is not a personal consultation for your specific immigration matter. If your question does indeed require legal advice specific to you, we will ask you to schedule a consultation with myself or one of our other attorneys so that we can give you the time and attention you need to address your concerns. So next, I want to let you know how to ask a question during the webinar. So you can ask questions at any time as we move along. So what you will do is there's two panels that we have here, or 2 options, but I would ask that you go to the question or ask a question panel, which is just below the video. If you scroll down on whatever screen on your screen, you should see a section called Ask a Question. That is where you should ask your question rather than in the chat pane. The chat section is really just if you have a technical difficulty or something that's more procedural rather than a question that you want answered. So again, go to the Ask a Question panel below your video, type your question, and just push the send option there. Also want to let you know we will have a recording or replay after the webinar, so you will be able to go back and listen to the questions that were asked and answered on this webinar as well. So we did have a few people actually send questions in advance. So I'm just going to go right in and try to answer the questions that we did receive in the order that we received them. And then we'll go next to the chat panel where I see there are already a lot of questions there. So we definitely will have a full session here with lots of questions that hopefully will be answered for those who are attending and be helpful to you. So one of the questions we received, and again, some of the questions I did receive had sort of identifying information, but I just want to kind of give a general answer in it. So one of the questions we received was a situation or a question about a child. So essentially what the question was is, I have a priority date in EB2 India, which is a specific date about 3 or 4 years ago, and I'm on an H-1B visa. So my oldest daughter is going to turn 18, will turn 18 eventually. So if she turns 18 and doesn't have a green card, what are the options there? So The question really, the answer to that is twofold. First of all, we have to understand that if you are in the green card process or on an H-1B visa, normally your children under the age of 21 are eligible to either have the dependent visa, which in a case of an H-1B is an H-4 visa, or also be eligible to get green card based on your employment or family, in some cases, family green card application. In this circumstance, what we're really looking at is the age of 21. So let's say if you're on an H-1B visa and your child who is on H-4 turns 21, then they were no longer eligible to be a dependent on your H-1B visa. That means they would need to find another status to remain in the United States. Oftentimes, what will happen is that the child will, maybe if they're going to school, change to a student visa. And in that way, they can actually continue on their own status as student until they graduate from college or graduate school, and eventually go on to get an H-1B visa themselves through the employment process. So it really depends on the situation, but in most cases, what we're looking at is to try to find a way to have that 21-year-old remain in the US on their own visa status. Now, in the case of the green card application, there is what's called a Child Status Protection Act. And that was enacted about 2000, in the year 2000, where, to address just this sort of problem where a child who is a dependent on the parent's green card application is waiting for and is on the waiting list for the green card, turns 21. What happens to that 21-year-old? Because technically under the law, someone who's 21 or older is generally not eligible as a dependent of their parent's green card application. So in this case, what we're looking at is if the child turns 21, while you're still waiting to get the green card, you have not, either your priority date has not become current and you aren't even in the adjustment of status process, or you are in the adjustment of status process. What happens when the child turns 21? So those are two questions in itself. If you are not in the adjustment of status process, you're still waiting for your priority date to be current to get to that last step of the green card process, and your child is over the age 21, they may still be eligible to eventually get the green card based on your application. However, the calculation is a little complicated to determine whether they're eligible. The way the government does this is that it will look at your I-140 application, when it was filed, and how long it took to process the I-140 application. So let's say, for example, if your I-140 took 3 months to process, what will happen when your child turns 21 and the priority date becomes current is that the government will subtract that 3 months from the child's age at the time that the priority date becomes current. It's a little confusing, but let me try to give an example. So let's say your priority date is current this month, and your child is 22 years old at this time. So what the government will do is say, okay, it took 3 months to process your I-140 application. As of this month, when your priority date is current, your child is age 22. We will subtract 3 months from the child's age to determine whether they're under 21. Well, of course, in this example, that probably won't be the case, because if they're 22 and we subtract 3 months, they're still probably going to be the age 21. And in that case, they are not eligible. So what we have to do is to see if we can, what qualifies a child is if their age is under, if they're considered to be under age 21 for CSPA purposes. So that's a complicated formula, as I mentioned. So we really have to look at it on a case-by-case basis. Ideally, you want the situation where it took a very long time for your I-140 to process, but that really doesn't happen nowadays. Most of the time, people will premium process their I-140, so it really won't be helpful to the calculation to try to lower the child's legal age under this process. The other scenario that could happen is that if your if you are actually in the last stage of the adjustment of status process, and your child has also been able to apply for adjustment of status because they were under the age of 21 at the time that your priority date becomes current, then you're in a much better situation. So as long as you are able to get into the adjustment of status process before your child turns 21, even if they turn 21 after, while they're in the adjustment of status process, they will still be able to get the green card, even if it takes 2 or 3 years later, which generally isn't the case. But let's say if you apply for adjustment of status and your child is age 20 or 21, 20 and a half, and he or she has applied for adjustment of status with you, then it's pretty much safe at that. They're pretty much safe at that point. They will continue to process their adjustment of status application, even though the child turns 21 during that process. So that's a long answer to a question. It is fairly complicated. So the sum of it is that it really just depends on the situation. But if you're still in a non-immigrant visa status and your dependent child turns 21 or is about to turn 21, then you need to look at a way of seeing if there's another visa status that they're eligible for in order to remain in the country with you. All right, the next question I had was, and we have a lot of people in the medical industry here, so many of these questions will probably be more related to those who are physicians or nurses. So next question I had was about CAP exempt visas, H-1B CAP exempt. So the question is, I hear a lot about CAP exempt and the lottery for H-1B visa candidates. For H-1B visa holders who want to get a job in the US, must their employers meet the CAP exempt requirements? Who determines the CAP exempt status, and are there CAP exempt employers that aren't not-for-profit institutes located in a medically underserved or academic institution? So those are a lot of questions, and it is a little confusing about CAP exempt. And so what I want to do is just kind of break down what we mean by CAP exempt and the lottery. Many of you know that with H-1B visas, there are a limited number of new H-1B visas available every year. Currently, it's 65,000 visas, new visas that are available, and an additional 20,000 for those who qualify under the master's degree cap. So if next year is anything like the past few years, usually you have about almost 200,000 applications for that very limited number of H-1B visas. Now, there are H-1B visas that are considered CAP exempt, meaning that they don't have to go into, they're not in that limited pool of visas. And the advantage of a CAP exempt visa, H-1B visa, is that you are not, first of all, you're not counted in the cap. You don't have to worry about the cap at all. And you can apply any time of the year. But what that means is that if you do get a CAP exempt visa, your options of changing employment are limited. So for example, if you've got an H-1B CAP exempt visa and you now want to go work for an employer who could apply for you for your H-1B, but their H-1B would actually not be considered CAP exempt, that means you're now going to go back into the lottery. So although technically, or usually someone who already has an H-1B visa that has been counted in the cap does not have to worry about the lottery anymore. However, if you have a CAP exempt visa, then you will have to consider the lottery if you're going to move away from being CAP exempt. And so how do you get to be CAP exempt? There are different options for CAP exemption. There's the CAP exempt employer option, which basically means that you are going to work for, there are 3 types of CAP exempt employers. One is an actual university or a government research institution. Those institutions are generally CAP exempt, so they can apply for H-1B visas for employees year-round without concern about the cap. Or you can be a nonprofit, the employer can be a nonprofit institution that has an affiliation with a teaching affiliation with a university or college, or they have a strong affiliation with a government research institution. So how that generally plays out in that scenario is that the nonprofit has what we call an affiliation agreement with a local university or college, where they agree to have interns from that local university or college come to their facility to get training in the specific occupation. So, for example, a nurse training program where nurses that are attending getting a BSN or an ASN from a university is coming to that particular nonprofit organization in order to get training as a nurse. So those are the second type of CAP exempt employers. And then the third type of CAP exempt employers are for-profit organizations. However, the actual place of employment, the location of employment, will be at a site that would be considered CAP exempt. So what do I mean by would be considered CAP exempt? I mentioned, first of all, the universities and government research institutions are CAP exempt. I mentioned that nonprofits affiliated with those universities or government institutions are CAP exempt. So if you are a private employer, but you have some agreement with a university, for example, that your employee will be working at that university for at least a little bit over half their time, what we say is 51% of their time, they're going to be working at that university, maybe on a joint project or some, for example, in a hospitalist situation where the doctor will be primarily working at that university hospital or nonprofit university affiliated hospital, then that employment would be considered CAP exempt as well. So anyone who is looking to avoid having to worry about the CAP would have to look at those employment situations to be able to actually be CAP exempt. So it doesn't really, the question did ask about were there any CAP exempt employers that aren't not-for-profit? And I mentioned the only one would be those who are not-for-profit, but they're going to have their employees work at a facility that is not-for-profit or university affiliated. So it doesn't matter whether they're in a medically underserved area. It really matters whether or not the location is would be considered CAP exempt if that university or that nonprofit university affiliated organization applied themselves for the H-1B visa. Okay, let me see. All right, let me go to the questions that I see under the pane because many of you are here and I want to make sure I answer the questions that you have. So I have a question. The first question here is there a way to know if the I-485 application has moved from the NBC, which is the National Benefits Center, to the local field office, which is the USCIS office, which is local to almost every city, major city. So the I-485 application, just to clarify for those who might not be aware, is the actual adjustment of status application, the last stage of the green card process. In the last year, the government stated that nearly all green card adjustment of status applications have to go to interview at a local, the applicants for a I-485 application have to be interviewed at the local field office. So local field office would be the nearest office to where you lived. So for example, if you lived in Dallas, we have a local field office, which is in Irving, Texas, which is a suburb of Dallas. So if someone has an I-485 application, eventually they will receive an interview notice to go to the local field office to be interviewed. But generally, as an employment application, adjustment of status application, you file with the National Benefits Center, you file with the one of the service centers, depending on where you live. The service center will screen and go through the whole process, and then they will eventually forward the application to the National Benefits Center, which is sort of a clearinghouse to take the applications and then distribute the application to the local field office where the applicant lives. So the question is, is there a way to know if and when that has happened, that the National Benefit Center has moved to the local field office. And after saying all of that, unfortunately, we do not know until we actually get an interview notice from the local field office. There is not a notice from the National Benefit Center to the applicant that says, okay, we've gotten your application at the National Benefit Center and now we've moved it on to your local office in Dallas, for example. The only way that we will know that is when we get an interview notice from the local office. Or in some cases, potentially you could call the USCIS and find out, try to determine if they will let you know that. They're not required to let you know where the case is moved to or not, but it's possible that the information officer that answers could tell you that information. But I cannot say definitively that they will absolutely let you know where that application is, whether it's moved from the NBC to the local field office. The next question I have is someone who's Canadian citizen doing a fellowship on H-1B visa, previously did the residency on J-1 visa. If I want to buy a medical practice in a J-1 waiver area, is it considered a J-1 waiver or can I buy it? So I think what the question is whether or not you can actually get a H-1B visa as a self-employed individual, meaning that if you buy a medical practice, then you will be the owner of that practice, and that would be considered self-employment as opposed to employment by another entity. So if that practice is in a J-1 waiver, that's a little complex question, but it really depends. Let me break it down this way. As far as the J-1 waiver is concerned, if you want to get a J-1 waiver as self-employed or buying the medical practice yourself, it really depends on the state. Some states, waiver programs will not allow that. Some might. So it really depends on the state. I will say it's very rare for that circumstance, and I have a feeling that most states do not like that situation. But we have seen that happen in the past. So it just really depends on the state. Now, even if the state says that there's a waiver, the next step would be to get the H-1B. And so if you want to get the H-1B, there is what I call a self-employed or entrepreneurial H-1B, which really pretty much is an H-1B like any other, except that you own a majority of the practice or the employer. And in that case, there are certain things that has to be done to structure your practice or structure your corporate structure in a way that meets the immigration requirements. So generally, I mean, I can't answer, can you buy it at this point, but I can let you know that it is possible, but it really depends on your individual situation. So this is certainly a question that I would say that if you really want to know or get the proper advice about that specific circumstance, I would certainly encourage you to contact us to schedule a consultation to really get all the facts and be able to advise you properly about that. Okay. So I'm looking at I'm hoping I'm doing this right, but hopefully I have another question here. Someone is asking, I have a primary and concurrent H-1B visa. If I can't get an extension of the H-1B for my primary, then can I stay in the United States on the concurrent H-1B, which is not stamped? Can I open a medical practice on the concurrent H-1B? So that's another question about opening a medical practice. That goes back to the same answer that I had with the previous question. There are ways to own your own practice or own your own business and get an H-1B, whether it's concurrent or full-time H-1B. But you have to structure the business or the corporate structure in a specific way. So it is possible to open a medical practice on a concurrent H-1B if it's structured properly. Now, the other question is that if you can't get an extension, if your primary H-1B is not extended and that pretty much expires, that if you have another H-1B, a concurrent H-1B with another employer or employment, then yes, even if your first H-1B expires, you are still permitted to stay in the U.S. with your concurrent H-1B, as long as you are following through on the terms of the concurrent H-1B, meaning that you are working where you said you would be working for the concurrent H-1B. It doesn't matter whether you have gotten a visa stamp for that H-1B, because a visa stamp really relates to travel and coming back to the U.S. It really does not affect your ability to stay in the U.S. if you have received that permission through having an H-1B approval. Okay, next question is, if you're on H-1B visa and became disabled or can't work full-time because of a medical condition, can you stay in the U.S. if you have an occupation-specific disability insurance? Is it advisable to get occupation-specific disability insurance? Well, for the second part of that question, that occupation-specific disability insurance probably is outside my area of expertise in terms of determining whether it's advisable. If you mean how it relates to the ability to stay here, in and of itself, having occupational disability insurance is not a substitute for employment. So if you have an H-1B, which requires you to be employed either full-time or part-time, but you cannot do so, and you are no longer, if you cannot do so, it really depends on your employer. If they are allowing you to continue to be an employee, and you are on disability, for example, for some period of time, then that could be considered to be, that could be that you are actually in compliance with the H-1B because you've not actually been terminated from your employment. But it does have, you do need to really, again, discuss that specifically with your attorney to determine how that's structured within your employment, so that there is not an issue in the future or currently about your H-1B status. If you have a full-time H-1B, but perhaps you can work part-time, then you can amend your H-1B, or your employer can amend your H-1B to change it to part-time employment, and therefore you will be in a situation where you're compliant in that sense. So again, you really do need to consult with an attorney to determine what the options are through your employment and what are the best ways to ensure that you don't violate the H-1B requirements. And I want to repeat here, because I probably need to repeat it again. We are only answering one question per attendee, so I apologize if you've asked more than one question. I will note your question and may get back to you individually on that. The next question is, if I take 12 weeks of state-approved maternity leave during my J-1 waiver job, do I need to extend the 3-year waiver period by an additional 12 weeks? So I typically believe that an extension is not required if you are within the government guidelines for specific leave laws. So for example, as you mentioned, 12 weeks of state-approved maternity leave, or in some cases, 12 weeks of federal government FMLA Act leave, then I believe that is not a reason to extend your 3-year period. However, if you go beyond that and take an additional time, let's say you take 12 weeks of the approved leave and your employer allows you to take another 12 weeks, maybe unpaid leave, and it's just an agreement between you and your employer, then I would say that that probably needs to be added on to be sure that you've not, that you have complied with the 3-year requirement. Because as you know, the 3-year waiver period says that you are to work for 3 years in an underserved area. And considering, of course, you were able to have vacation time and sick leave and that sort of thing. But if you are, unable to work for extended periods of time, then that would not necessarily comply with the 3-year requirement. So again, if you are within the 12 weeks or within the state approved maternity leave time, which is government sanctioned, then I would say you don't need to extend. But if you go beyond that, and your employer agrees to allow you to go beyond that, then you would need to extend that 3-year waiver period. And how that works is that you would not be considered to have completed your 3 years until you've added on whatever time that you took off to that time frame. The next question is, for the EB2 national interest waiver, must the employer have a sliding fee scale in place, or being in MUA or HPSA are good enough? So that again depends on the state. Generally, for the federal government, there's not any requirements in terms of sliding fee scales or any employer requirements other than having an agreement or the possibility of working for 5 years in an underserved area. But states also have to weigh in on that, and a state has to give their public interest letter. And some states will almost treat it like a J1 waiver and require a lot of, or place a lot of requirements on the employer, like a sliding fee scale. So it really depends on the state itself, whether it is. In most cases, and in our experience, most states don't have that type of requirement, but there may be a few that do. But generally for the federal government requirements, all that's needed is being in an MUA, HPSA, and having an agreement or your agreement to work for 5 years in an underserved area. If there are any more questions, I'd be happy to take some more. I'm kind of at the end. I understand that we have more than one question, and since if we don't have another question, then I will go back to those who asked more than one question. Again, I want to remind you that if you are asking a question, please put your question in the Ask a Question panel underneath the video, not in the chat pane. So if you have a question, if you want to move that question over to the Ask a Question panel, that will help me to keep track of the questions that are being answered and be able to do that appropriately. So if you have a question, again, please make sure that you put that question into the Ask a Question panel underneath the video. Just scroll down and do that. So while we're waiting for a few more questions, I see there are a lot of repeat questions here, and since I haven't heard I don't see a new question yet, I will start with another question from a person who previously asked a question. So can your spouse on H-4 visa open a business in partnership with a green card owner? So I'm assuming that the spouse on H-4 does not have a work authorization. H-4 is typically a visa does not have work authorization associated. There is an H-4 EAD, employment authorization document, available if that person, well, it's still available. It may not be available in the near future, but if you qualify for the H-4 EAD or your spouse qualifies for the H-4 EAD, then they need to get that EAD in order to open a business. And I'm assuming that what you mean by opening a business is that your spouse will be actually involved in the operations of that business. They're not just depositing money or investing money and waiting for the profits to come from that business. If they are going to be actively involved in general, then they should be sure that they have work authorization to do so. All right, the next question is, if you start your 3-year Conrad 30 J1 waiver, can you finish it 2.5 months early by taking vacation in the end? Again, this is a very specific question. I need to answer things generally because this is an informational session and not an advisory session. So I want everyone to keep that in mind. Do recommend that for specific circumstances, you should consult directly with an attorney so that additional questions that may be out there, additional questions that the attorney might have, and follow-up questions that you might have can be fully answered. But just in general, I will answer that if you have an agreement with if you have vacation time, which most cases you will, if you have vacation time, that usually is paid vacation or at least agreed vacation as part of your employment contract. So if you decide to take your vacation at the end of your 3 years, that 2.5 months early, as you mentioned, or 2.5 months of vacation time is actually considered employment time. So if you take that 2.5 months at the end of your 3-year contract, you still comply in general with your contract. So that should fulfill the waiver requirement as well. Right. I have one new question I want to answer. It says, can I do a locums at another place or I guess it's tele ICU while doing a J1 waiver job? If you are doing a J1 waiver job, that means you have H-1B visa, which is limited to the specific employer. If you want to work at another employment, whether it's locums or whatever the specific type of employment it is, you will need to get an H-1B in order to work with that specific, work in that particular employment. So you can get what's called a concurrent H-1B. I mentioned that earlier. And concurrent means simply that you have 2 or 3 or 2 or more H-1Bs with different employers at the same time. So with your primary J1 waiver job, you will have an H-1B. With your part-time or locums or whatever moonlighting job that you will have another H-1B. So you can do that as long as you get the H-1B approval to do so. Okay, the next question I'll answer is, the question was Alabama State. I think this is a follow-up of the previous question about buying a medical practice. Honestly, I don't have the information on Alabama. I would have to go and look at their actual requirements. I will say that Alabama tends to be a very difficult waiver state, very, very restrictive in a lot of things that they do. So I would say I doubt that it does allow the buying a medical practice to complete the J1 waiver or to be approved for a J1 waiver. However, I can't say for sure whether or not it does or does not allow you to buy a practice and get a J1 waiver in that state. Can I open an LLC and I'm the only one who works as an independent contractor for a hospital? Can I sponsor my own H-1B? So this goes back to, I think, a couple of other questions that really go back to the same thing, is that yes, you can have what's called a self-employed or entrepreneurial H-1B. They are approvable. I won't say they're always approved, but if you structure the LLC in the way that the government says it should be structured in order to qualify for a entrepreneurial H-1B, then yes, you can sponsor your own H-1B through your LLC if it's structured the appropriate way. Just to give you a general idea, if you're 100% owner of an LLC, then the government requires to get an H-1B that you have what we call either a board of directors or a board of managers of at least 3. I say at least 3, and that's what's worked for us in the past, to have at least 3 other individuals who are on that board of directors or board of managers who have the ability to hire, fire, or otherwise control your employment. So even though you are the only member or owner of the LLC, this board of managers would have the power to terminate your employment if need be. So it's very unlikely to happen. I've never seen it happen, but it has to be set up in that way so that that board of managers has that ability, because the government wants to feel that there is another person or entity, not entity, but a person or persons who has control over your employment. They do not want you to have 100% control over your employment. Let's see, the next question is, do I get a waiver completion letter after 3 years? That is up to the state, and you can ask for one. It's not something that they normally, that we have seen that states automatically give to any physician who's completed the waiver. So that could be something that you ask for from them. We generally don't need it for purposes of getting your green card in the future, because it will be important for you to prove that you've completed your waiver if you are applying for the green card. But that happens at the adjustment of status stage, the last stage of the green card process, where you will have to provide proof that you did complete your waiver. And how we generally do that is by tax returns for the 3-year period, W-2 forms for the 3-year period, and usually a letter from the employer, your J-1 waiver employer, that states that you worked from the start date to the ending date, which should cover the full 3 years. So a waiver completion letter from the state, if that's what you're asking for, is optional, and it's something that you can get from the state, but you don't technically need it. Next question is, if I hold an EAD, advanced parole document, or someone holds a EAD or advanced parole document, can you enroll in school and get an F1 visa from the home country? If you're holding an EAD advanced parole document, that means you're applying for adjustment of status. You're in the green card process. Now, if you're in the green card process, certainly in most cases you can enroll in school. Now, depending on what how you're getting the green card, that's going to be something to discuss with your lawyer. Is if you're planning to go and get to enroll in school and not continue to work, but your green card application is based on you working, then that might be an issue. If it's not an issue, then yes, certainly you can enroll in school and not jeopardize your green card application. But if you are trying to get an F1 visa at the same time of having an advanced parole, it's very unlikely that you're going to get an F1 visa. And the reason why is that F1 visa, which is a student visa, requires that you prove that you will return to your home country after your studies are done. If you are applying for the green card, the government is not going to believe that you plan to return, because it's actually the opposite. And in applying for the green card, you have stated that you want to remain as a permanent resident in the United States. So those are two very opposite statements that you're making if you're applying for a student visa. So it's probably, I would say, almost 100% chance that you will not get an F1 visa if you have applied for the green card and have an EAD, advanced parole document. All right, next question. Just go into the next question. I am on an H1 sponsored by my group. It's not keen on giving me partnership, saying that I cannot be owner of the group that's sponsoring the visa. And I'm sorry, I'm just trying to read it here well, so hopefully it's understandable. But I think that the question is, can I be a partner in a group and still be on H-1B visa with that group being my H-1B employer? And the answer is yes. You can own a part of a business or all of a business. As I mentioned before, you can even own 100% of your practice and sponsor yourself for the H-1B visa if you structure the practice in a certain way. But if you are not owning 100%, maybe you own 5% because you're part of a group, or even 20% or 30%. That is perfectly fine. The government does not say that you cannot get an H-1B because you own some percentage. What they will look at is how much control you have over your employment. If you're a 5% owner of a partner, or a 5% partner in a medical practice, more than likely you don't have that much control still over your employment. Your partners still have a big say in how you will be employed, how you'll be compensated, what you will be doing as part of that partnership. So the government understands that and still believes that even as a 5% owner, 10% owner, 20% owner, you are still your employment is still controlled by your employer, which is the partnership. So there is no strict prohibition against ownership or partnership ownership for an H-1B visa holder. But again, it depends on the specific circumstances. But in most cases, I would say that it is possible to be a partner and have an H-1B. Now, what is important also, because what happens sometimes is that people will say, I can't be a partner, and it's because the partnership is restrictive. And what I mean by that is the partnership does not wants to compensate based on your productivity. They do not want to give you a fixed salary or fixed compensation. And that could be an issue, not so much the ownership, but the issue is if the partnership isn't willing to agree to give you a fixed salary based on the prevailing wage required by the H-1B, then yes, that won't work, because the partnership still has to agree that even though you're a partner, you will be paid, let's say $150,000 a year, because that's the prevailing wage in your area. And that is required in order to meet H-1B requirements. I have a question from a new person, so I'm going to go to that one first. Can you lose your green card status if you prematurely end your contract with a sponsored employer? That is, if you were sponsored by an employer and you have a green card, well, let me say, if you were sponsored for a green card by an employer and you have worked with that employer, there is nothing in the green card rules now that say that you have to work for a specific number of years or time in order for you to maintain your green card status. In fact, once you get the green card, you're a permanent resident. So you do have the ability to work and live anywhere. You're not restricted to any particular employer after you get that green card. However, if you plan to apply for citizenship in 5 years, for example, you may get the question of whether you worked with a particular sponsoring employer. And the reason that question comes about is because when you and your employer agreed to go into the green card process, the agreement that you made with the government is that you will work with that employer once your green card has been approved. So, but it doesn't say how long you have to work with your employer. So the question could be at citizenship time. Did you work with your employer? Not necessarily how long, but did you work with your employer once you got your green card? If you did, then it would be very difficult for the government to determine that you did not intend to work with that employer once you got your green card. So in short, you did fulfill the requirement that you would work with the employer once you got your green card. If it was 1 month, 2 months, 3 months, the government might want to know, well, what happened? Why did you leave so early? And if you have reasons for doing that, they may consider that to be perfectly fine. It's very rare that the government does not or revokes a green card. And actually, I've never seen in my practice where a green card has been revoked because the employee did not work, a month or two, or did not work for 6 months or a year or whatever after receiving the green card. If you worked with the employer after receiving the green card and you have a good reason why you left the employer, let's say you said prematurely, then you should not have an issue with respect to your green card. So there's no automatic losing of your green card status just because you ended your employer. It really comes up later during the citizenship process. All right. Next question I have is, I'm doing a J1 waiver job currently. If I'm filing a concurrent H-1B with another employer, does it need to be in a J1 waiver area as well? In our experience, it doesn't necessarily have to be, and I think what you mean by the J1 waiver is whether it's an underserved location. In our experience, it doesn't. The government has approved applications that aren't in a J1 waiver area or underserved area. However, technically, there is a rule that says it should be in a J1 waiver or underserved area. But in most circumstances, we've not seen that held up. So you can apply for it. I would suggest to, if you are interested in applying for that with another employer, and that employer is not in a health professional shortage area, MUA, do consider that it's possible that employment would not be approved, but in most cases, that type of employment has been approved. I think this will be the last question. I do see one in the chat pane, and I might go to that one, but the last question I see in the questions pane is, could my husband buy a medical practice on E2 visa, sponsor J1 waiver to me in Alabama? I am Canadian citizen. Okay. Again, this is really a very specific question, and I would ask that you really consult with either myself or another attorney to really get an understanding of that whole process and look at the different options there. I cannot give you advice with respect to whether you can do these things. It really, without more, there really needs to be a specific advisory session to discuss all of these options and try to see what your goals are in that case. But it might be doable. I'm not saying it's not, but we really do need to have a consultation or you need to consult with an attorney to make sure that you get the time and the advice that you really need to determine what that option is. Okay, last question I see here, which I will answer again, we still have a little bit of time, so if you have a question that has come up or you hasn't been answered, please go ahead and put that in the ask a question pane. I see a question in the chat pane. I'll just briefly answer. Can I start, someone on an E2 visa, can I start the application even if the business isn't running, so to speak, is starting and the investment is being made? So that question is about an E2 visa, which is what we call a treaty investor visa that's available for certain nationals of certain countries that are part of the treaty with the United States. So in that case, the E2 visa requires that the individual make an investment into a business. It could be an operational business where you're buying a business, or it could be a startup business. If it is a startup business, then you have to get that business to the point where it is nearly operational before you apply for the E2. And what that means is that everything is set up, ready to go, so that once you get your E2 visa, the next day you can practically open up the store, so to speak. So if you still have a lot of things to do, maybe you've just put in the money, but you haven't found a place to rent, if you need a storefront, you haven't bought the equipment, or at least have a contract for the equipment that you might need. If you haven't done the things that are necessary in order to get that business to the stage where it can start operating any day after the E2 visa, or immediately after the E2 visa is given, then you probably will not be able to get the E2 visa. The government isn't going to just give you an E2 visa based on a plan of opening up a business. They want to see that you are near to the point where you've done almost everything you can, or everything you can to be able to operate that business, but you just need that E2 visa to get started and actually start to, open the store, so to speak. Okay, I have another question. Once a person completes 5 years on a national interest waiver, which is for physicians working 5 years in an underserved area, what visa will they be issued if their priority date is not current? There actually is not a visa associated with the national interest waiver. So the national interest waiver is your green card, is a green card application. You are only required to work for 5 years in an underserved area to meet the requirements. But as the attendee said, after you've completed the 5 years, you may still not be able to get your green card because your priority date is not current. So you're not able to apply for adjustment of status yet. You're not able to get your green card yet. So what you will have to do in order to remain in the US and continue working is to get an H-1B visa. You still have to continue with the H-1B visa until your priority date becomes current, and ideally, I would say until you actually get the green card. If you have applied for the national interest waiver, you have an approved I-140. So you are not limited to 6 years on the H-1B visa. You will be able to continue getting H-1B visas until your green card is issued. So that's pretty much the visa that you will be getting, is the H-1B, and you have to keep complying. You or your employer will have to keep applying for you. Now, the good thing about it is if you completed the 5 years on the national interest waiver, your H-1, you can work anywhere. You're not restricted to working in an underserved area anymore. So you will get an H-1B, but the H-1B might be in an area that is not underserved, and that's fine. That's not an issue. But you will have to keep an H-1B in order to maintain status in the US, in most cases. Next question is, can we do a new waiver job if I need to go back home for an emergency and leave the first 3-year job incomplete? That's a little complicated. And again, I hate to keep saying the same thing. It's probably something you really need to consult directly with an attorney before you make that kind of move. But in general, if you don't complete your 3-year waiver job, then you are back to having the 2-year home residency requirement. So that means you have to go back home for 2 years, and then you'd be allowed, you can come back with, H-1B if you're eligible, or another visa, depending on the circumstances. Or it's possible that you could apply for another waiver. So yes, it is possible to apply for another waiver, but that means your whole 3 years are starting over again if you apply for a waiver. It won't be taking up the remaining time. So if you've already worked for 2 years and you leave and you want to get another waiver, you're going to start 3 years again. So yes, in general, it is possible to do a new waiver job, but consider that you'll probably be starting all over again. And I can't say, whether the state in knowing that you, a state waiver program and knowing that you didn't complete a waiver would give you another waiver. It is totally up to the state or federal agency that is responsible for waivers to determine whether or not they're going to do that. So someone asked the question about, does that apply to even the national interest waiver on merit extraordinary ability? And I think that related to the question about the 5-year national interest waiver, whether the H-1B, whether there would be a visa, or what kind of visa would you have once you completed the 5 years. So if the question is, if you have a national interest waiver based on merit, which I think is exceptional ability that you're talking about, it's not the 5-year physician. If yes, I would say the answer is still yes. If you have been approved for the other national interest waiver, but your priority date is not current, you will still need to maintain visa status through an H-1B or other visa if you are eligible. But there is not a specific status that is awarded just by getting a national interest waiver, whether it's through the 5-year physician or based on the exceptional ability. Those are just eligibility for the green card. You still have to get to the last stage, which is the adjustment of status. And that part is the one that is eluding a lot of people, because it is that's where you're waiting on the priority date list, waiting for your immigrant visa to be available. So the answer is yes. Even if you've been approved for the national interest waiver, either way, you are going to have to maintain H-1B status until you actually are able to, until your priority date becomes current and you're able to get into the adjustment of status process. Okay, I don't see any further questions. Let me just one more call for questions. And then I do want to reiterate, I see one coming up, but I do want to reiterate to everyone that immigration law is very complicated. As I've mentioned several times, you know, that you really should consult with an experienced immigration attorney to get specific advice about your particular needs. What we've discussed here has really been general questions, and I try to, you know, make sure that you understand that it's general answers, because each circumstance, there's no cookie cutter case, there's no case that's exactly like another. So really, it's very important, particularly considering today that there's a couple of things coming out with immigration policy in particular. I don't know if some of you probably have heard about the idea that if your application is denied, there will be a much quicker, and it's determined that the denial would put you out of status. So for example, if you apply for a change of employer and that change of employer H-1B application has been denied, and you are no longer employed with your former employer, then you could be referred to removal proceedings or deportation proceedings pretty quickly. So it's very, very important to make sure that before you do anything relating to immigration, that you consult and make the investment to consult with the immigration attorney, just to make sure that you're getting that right advice. So still see two more questions, and then we'll end with those two from there. For the EB-5, can you take the loan from U.S. banks for capital investment, or it has to be in cash? Can you open a medical practice with it? So loans are possible to count as part of the investment for EB-5 program, whether it's from U.S. banks or somebody lends it to you personally, but it does have to be structured in a particular way. And in many cases, so for example, the government will consider a loan if the loan is based on your personal commitment, meaning that you can't take a loan based on you pledging business assets. It has to be personal assets that are pledged to the loan. Typically that loan is for a short period. Generally, we look at about a 2-year payback period. So there's a lot of, you know, ways that there are ways that you can come up with, determine whether the investment meets the requirements, but you do have to be sure that if you are going to take a loan, you have to structure it in a particular way. So with the time we have right now, all I can say is that yes, it's possible that you can use a loan as part of your investment, but it has to be structured in the right way. Yes, you can use for an EB-5, you can use or open a medical practice as your EB-5 investment, but keep in mind that your EB-5 investment requirement is $500,000 at minimum, depending on where you locate your medical practice. And that medical practice has to have the ability to start or employ 10 people over a 2-year period. So if your medical practice is going to be that large, then yes, it's possible that you can use the EB-5 program to get your green card based on opening a medical practice. So the last question is, I've done residency on J1 and doing fellowship on H-1B. I had to get my H-1 visa without doing J1 waiver as a Canadian citizen. Is there any way to get an H-1B visa without doing a 3-year J1 waiver job? Okay, so I think what you're saying as a Canadian citizen, yes, Canadian citizens who have been on J1 can get an H-1B without a waiver. It's sort of a loophole there. However, if you want to get permanent residence, green card, you are either going to have to do the 2 years in your home country, or you're going to have to get a waiver. So it's not, yes, you can get an H-1B, but the issue is, can you get permanent residence? And if that's your long-term plan. So if you do want to, eventually become a U.S. citizen or at least get permanent residence, you are going to either have to do one of those two things: 2 years in your home country or 3 years in a waiver job. Now, the 2 years in the home country is a cumulative calculation. So that means after you've done your J1, every day that you spend in your home country counts towards the 2-year requirement. So if you can prove that you have cumulatively been in your home country for 2 years after your J1 waiver, then you don't need, not J1 waiver, after your J1 visa, after you've completed your residency on J1, then you don't need to get a waiver. But if you can't do that, or if you don't want to, stay outside the U.S. for 2 years, then you're going to have to get a waiver in order to eventually get your green card. All right. Well, I want to thank you all for attending today. I think I'm still seeing some questions here, but let me see. I just want to remind you of our information, so feel free to contact me with your questions. Again, I may ask that you schedule a consultation if the questions do require a bit of time and I need to spend time with you to fully advise you. But again, I want to thank you for being with us today, and have a wonderful day. Thank you.